This is an introduction to family law for Chapter 1 of the Lupino and Fitzgerald textbook. So this will be a short introduction to some of the key points that are useful in understanding at the outset. We'll cover 3 key points here: effective interviewing, today's world, and no-fault divorce. First, a paralegal's responsibility is often turns to interviewing new clients, and not just new clients, but clients who are already established in the firm. It's important, though, to understand, first of all, that there are some considerations to take in to make the interview effective with the client. First of all, you need to consider the sensitive nature of the family law practice. People are involved in for example, dissolution of marriage, otherwise known as divorce, and they're under some pretty serious emotional pressure. And they're also having to discuss things that are very, very personal to them. Maybe adultery, maybe domestic violence, even incest, and other very heinous situations. So you need to be sensitive to the nature of the family law practice in general, and why the client is there is often very traumatic for them. Also, you need to understand that the divorce, especially, or also known as dissolution of marriage, is highly adversarial. It's a very adversarial nature most of the time, or many times, and because of things like abandonment, drunkenness, many situations that, again, fall under the sensitive nature, are also bring about some adversarial problems. And of course, children, money, property, those 3 things are at the high stakes category of the dissolution of marriage, and as such, recognizing that these are really highly adversarial areas in dissolutions. Respect, you have to respect the person that comes in there, no matter what they've done to their spouse, no matter what they, even if they've been maybe acquiesced to family violence or other really serious concerns. And it's not our job in interviewing them or talking to them at any time to give our opinion or our judgment about their activities. So it's very important to stay neutral and take in the facts, listen actively, letting the person know by your body language and your discussion with them that you are listening, that you're hearing them, and you're not making judgments or opinions about them. Body language is one of those things that, even if you try not to express your judgments and opinions outwardly through your verbal, your use of your language, it still can come out in your body language. So paying attention to how you're responding in body language format is really important too. Next, take notes. Always write down what you are, the information you're getting from a client. It's very easy to forget or to try to recapture it later. It's basically impossible. So taking down notes, getting the information from the client, using a fact-gathering procedure, and that's usually something that you're trained to do by the firm you work for, by sitting in on interviews over a period of time. That's really important, is to make sure that it's important to make sure that you work for someone who's willing to show you how they do it, let you sit in on interviews until you understand it, and then be supervised for your first few interviews to make sure that you are you have some guidance. UPL, those are the initials for unauthorized practice of law. And in short, there are a few things in Chapter 13, I believe it is, that cover the ethics of the paralegal profession, but unauthorized practice of law is very important in client interviewing. Client might ask, do you think I have a good case? You can't tell them your independent legal advice. All legal advice needs to come from the attorney and the attorney only. And so you can act as a conduit if your attorney has told you something about the potential outcome of the case, which should be unlikely. It's very hard to predict with 100% certainty what the outcome of a case will be. Nonetheless, you need to, be very careful about not giving your own independent legal advice, even if you know the answer. All right? Unless your attorney has directed you, given you the advice, told you it's okay to tell the client the advice, just don't do it. And defer to the attorney, explaining to the client, I can't give you any legal advice. I would be glad to pass your question on to the attorney and let him or her answer it for you. So those are some key critical points on effective interviewing of dissolution of marriage and other family law matters. Next, a little bit about today's world. You read about it, I'm sure, in the book. And divorce is no longer the stigma that it was in the past. Even I'm in my 50s. I won't say how long, but when my parents divorced when I was in 3rd grade, it was a social stigma. We were in a small town, and it was really not as detrimental to the to our standing as it would have been 50 years before that. But the book goes into some good history about, the early 1800s versus today. Okay. Sorry, I lost my place because of my dogs. They were barking. But society has evolved to accept the dissolution of marriage as better than staying in an unhappy union. In addition, people long ago felt they had to be married. A lot of this had to do with women's rights to property, rights to having credit cards of their own credit. This was a serious impediment in the past for women. And so remarriage was really common, but it is truly optional today. In the past, also, there were certain presumptions that a man was always responsible for the financial maintenance of his wife and children. But now that women work outside the home and they earn an income, they're often even better providers than their male spouses were. So that's a change in today's world that that our society has recognized and is perfectly satisfactory. In addition, NoFault Divorce came around. In the first state to enact NoFault Divorce was California. Prior to NoFault Divorce, parties had to satisfy the courts that the requirements of the grounds for divorce, which included things like adultery, abandonment, mental and physical cruelty, they had to show that those requirements for divorce had been met. Now parties simply swear under oath that the marriage is irretrievably broken. In Florida, we call it irreconcilable differences, and no party is to blame. So cohabitation also outside the marriage, outside of a marriage, is no longer an illegal act. It used to be illegal, and it's far more commonplace today. So now that women can own their own property outside of marriage, cohabitation is more common, and for a number of societal changes. A little bit more about no-fault divorce. There were limited grounds for divorce. They're no longer required in most states. Parties seeking divorce, again, had to prove to the courts that they had facts that supported the requirements of various and very limited, actually, grounds for divorce. They had to prove physical or mental abuse, such as habitual drunkenness or abandonment or adultery, for example. Often these requirements were difficult to meet, so the parties mutually wanted a divorce, would collude with each other, and they'd create facts to meet the particular requirements. In this fault-based era of the past, the law played an important part in both the granting of divorce and in the determination of the amount set for alimony awards and the distribution of marital property. In the 60s and 70s, with public support, the legislatures modified the divorce laws, and that meant it to include no-fault divorce as a ground that the marriage had been irretrievably broken. We use irreconcilable differences as a standard in Florida, which is pretty much the same. It's just it's a matter of the word choice. So today, neither party would be required, in other words, required to sling mud in order to get the divorce. And the one thing that was more prevalent in the past than it is today is the punishment for those misdeeds, like the adultery, the habitual drunkenness, etc. There are laws in Florida, as there are in other states, that allow the judge to look to adultery and family violence in areas such as awarding property distribution between the parties, because every marriage, well, most marriages have some property involved, and adultery and family violence can come into play in areas like child custody, property distribution, but it's important to recognize that it does not have the the very profound effect as it did in the past. So it shouldn't be forgotten that it does exist. However, it isn't as poignant of a situation today. All right, so in conclusion, these 3 points are some important ones to at least get our feet off the ground in terms of the introduction to family law course, effective interviewing, today's world, and NoFault Divorce. The book has, of course, a full chapter on much of this, and I hope you'll read that. These were just some points that I felt were really important to get across to you in a quick interview.